I'm going to start by acknowledging country. We, as the panel, acknowledge the Wurundjeri people of the Kulin Nation. I pay my respects to elders, past and present, and I pay my respects to all First Nations people in the room, your elders and ancestors. I also wanted to, I don't think Uncle Herb's here anymore, but I really loved his performance this morning, and I wanted to let him know that I was going to go home and Google him and show my little son his Gumleaf music. I thought it was so excellent. I also, before we start today, wanted to acknowledge a couple of people that we've heard from over the conference that have really resonated with our presentation today, which is the Gunditjmara aunties yesterday, and Samara Fernandez-Brown and Nick Espy, who spoke to the activism of their families, who will also be speaking to the activism of families in this presentation today, and the impact that they have had on law reform in Victoria. I wanted to acknowledge the trailblazers in those aunties, the strength, resilience, tenacity and power of families who use their experiences, and in particular their grief, to prompt change and move systems. I just wanted to provide a content warning, a cultural warning at the beginning of this presentation. We will be using names and images of Aboriginal people who have passed. We've heard at the conference over the last few days about some of the recent law reform in Victoria, which has been aimed at addressing the overrepresentation of mob. Changes in law around bail, public intoxication and raising the age of criminal responsibility have long been advocated by various people in the sector. But the disastrous impacts of these laws have been most acutely felt by Aboriginal and Torres Strait Islander families. There are examples of discriminatory laws and practice throughout the country, and we were hoping to draw on examples from Victoria to provide some examples for the rest of the nation in terms of law reform and systemic change. Emily and Ash will speak to advocacy that's resulted in law reform, where despite numerous reports and recommendations, in Victoria, changes to the law have been most successful from the strength and campaigning of Aboriginal families who have lost loved ones to the system. So my first question to you, Emily, is based on the Victorian experience, what have you seen happen when First Nations families are at the forefront of law reform and advocacy?
Thank you, and also it's an honour to be here today and listen to all of the amazing speakers over the course of this conference. Thank you for the question. So firstly, I just want to start by saying that there's no way that we could possibly summarise or categorise every single family that has done something for First Nations communities and mob that have fought every day for centuries now. So the focus today, though, will be on the last 12 months, the reforms that have occurred, and the two main areas that we were going to speak about is the decriminalisation of public intoxication in Victoria and also the reforms to bail that have occurred earlier this year. So one example that stands out and comes to mind when it comes to the decriminalisation of public intoxication is that of Aunty Tanya Day. She was a proud Yorta Yorta woman, mother, grandmother and sister. In December 2017, she tragically passed away after being arrested for public intoxication, and she was only 55 years old. Despite causing no disturbances, Aunty Tanya was arrested after she fell asleep on a V-line train and held in a concrete cell at Castlemaine Police Station. She fell and hit her head, and that later resulted in her passing away. Despite the requirement that she was checked on regularly every 30 minutes by police, this didn't happen. There was approximately a 3-hour gap from her fall to when police noticed and conducted a physical check to see bruising on her face, and an ambulance was subsequently called. And in a very dark and clear example of this continued systemic racism and tragedy throughout Australian history, Aunty Tanya's late uncle, Mr. Harrison Day, also passed away in police custody some years earlier in 1982. And this was from an epileptic fit after being arrested by police for an unpaid fine of $10 for being drunk in public. These are particularly poignant examples of how the systems have failed First Nations Australians and have actively operated to oppress us for generations, and that governments did not act despite having recommendations years ago. The tough on crime politics and rhetoric relies upon making people anonymous, and people get trapped in a legal system where they have no voice. Their life circumstances are stripped from them, and their stories are told about them in the courts and the media and public opinion. After Aunty Tanya Day's passing, she did have a voice though. This was led by her family, who were active in many spaces across the courts, the media, at rallies, inside Parliament and door knocking. They didn't let the system move on, and they didn't let Victorians forget about her. They were able to tell the stories of who Aunty Tanya was and how the systems had failed her. They mobilised door knocking to speak to Victorians about decriminalising public intoxication and it being a health response as opposed to a criminal response. And they built support for this reform. They utilised a multidisciplinary approach through the help of lawyers, political campaigners and media professionals. This is something that experts in Victoria had been speaking about and advocating for a very long time amongst themselves, and that also includes Recommendation 79 from the Royal Commission into the Aboriginal Deaths in Custody, which was made over 30 years ago, which was a recommendation that clearly stated that across Australia, if there are jurisdictions that still criminalise public intoxication, that it should be decriminalised and abolished as soon as possible. The Victorian government, as we know, didn't act on this, and then history repeated itself with Aunty Tanya passing away. But having a grassroots community support and a personal story and a voice for Aunty Tanya allowed Victorians to connect. This was a really vital part of the fight to decriminalise public intoxication, and it highlights the power of a grassroots movement. The results of what they were able to achieve resulted in the decriminalisation of public intoxication in Victoria. As of the 7th of November 2023, this came into effect, and it's now to be a health response. As with any changes in law reforms, there are teething issues, and there is still a build-up that is happening to have enough health responses in place, but it is certainly something that Victoria is working towards. We also see the impact of family-led advocacy changing the way organisations work, and it's also opened up spaces for other organisations. So, for instance, our Wirraway team at VALS was created to hold police to account and to assist families of loved ones who have lost somebody in custody. And also a shout out to April Day, who is Aunty Tanya's daughter, for setting up the Dajua Foundation. This helps other Aboriginal families advocate for their loved ones who have died in custody. And this also includes Veronica Nelson's family, who I will touch on in a little bit. The strength and leadership of mob is powerful, and making it easier for the next family to get justice is powerful. It's something we should all admire and support, and ensure that whatever organisations we're coming from, we do what we can to uplift those voices and amplify them. And I suppose the take-home message here when it comes to law reform is that you're ensuring that your organisations are utilising every support you can throw at Aboriginal families to make sure that they are at the forefront of this and they lead the changes, because it's unmatched what they've been able to achieve in comparison to experts in their policy rooms. Thank you.
Thanks, Emily. I think that leads really nicely, Ash, to where mainstream organisations such as Victoria Legal Aid, who hold a statutory function, can get involved in law reform as led by families.
Yeah, that's right, Audrey. Thank you. Organisations like Victoria Legal Aid, who are statutory authorities, play an important role in the Victorian legal system. A part of our function is to make recommendations to the Attorney-General about reforms to laws that have come to VLA's attention through our work, the work we do with people we represent. And through these examples Emily's talked us through, the power of the Day family of seeing, that change take place, and it challenges statutory authorities like Emily said, people sitting in positions to listen to the mob that it affects and not consult with, truly sit down, listen and hear their stories and make those recommendations to the Attorney General for law changes. And, we need to start thinking and considering about how we transfer that power and decision making to communities so that laws are created by the people they affect the most.
Thanks, Ash. I think the one of the most incredible things that I see out of the Day family, and you've touched on Gunditjmara, I think that April setting up that foundation is just wonderful. I think Nick touched on it yesterday, but dreadful that an organisation like that has to exist, but that April is there to support families, and other people like Samara are there to support families is really quite moving. But from a law reform perspective, that there's been, over 30 years of recommendations made around changes to public intoxication, and grassroots and grounded experiences of families really create a huge paradigm shift where something that was once criminalised is now a health-based response is really very remarkable. And I think sometimes we get bogged down in the law reform of it all, but it really is such a huge shift that this family have been able to really create and move Victorians forward with that change. I guess touching on that and the impact of First Nations voices leading law reform, Emily, can you speak to recent reform of the Bail Act in Victoria?
Thank you. So this may not be a surprise to many Victorians in the room, but there were bail reforms this year in Victoria as of March. And again, this is another example where First Nations families were pivotal in this change occurring and were at the forefront of this advocacy. We wouldn't be here today speaking about these reforms if it wasn't for the Nelson family. So Veronica Nelson was a Gunditjmara, Bundjalung, Audrey and Yorta woman who passed away at Dame Phyllis Frost Centre on the 2nd of January 2020. This was days of crying out for help, including to her father who had already passed away. I would also like to take a moment here to just acknowledge and speak to how Veronica's family described her and highlight how she is far more than what the circumstances were that led to her tragic passing. Auntie Donna Nelson described her daughter Veronica as a kind, caring and compassionate woman. She was loved by her family, her community and her friends. She was a proud Aboriginal woman who loved her culture. Her lifelong partner, Uncle Percy Lovett, described Veronica as a kind and loving girl who would always help people no matter who they were. She taught me everything I know about Aboriginal culture. Victoria's unfair and discriminatory bail laws put Veronica in prison for non-violent offending that was shop thefts and failing to appear on bail. These were laws that disproportionately discriminated against Aboriginal people. Veronica passed away in that prison, alone and isolated from her culture and her support networks. VALS represented Uncle Percy Lovett at the coronial inquest into the passing of Veronica. And it's also at this point that I would like to note and pay my respect to Uncle Percy. He did pass away peacefully in November of this year after many years of fighting for justice for Veronica. And he was also a member of the Stolen Generations, and he deserved more time than what he got. So VALS supported Uncle Percy and family to do advocacy through media, protests and in Parliament, including introducing a question to Parliament. We were pushing for and still are pushing for Pockham's Law, which is named after Veronica's nickname Pockham. And this advocacy included seeking changes to bail on a few main things. So firstly, the removal of the presumption against bail. Second, granting access to bail unless prosecutions show that there is a specific and immediate risk to the safety of another person, a serious risk of interfering with a witness, or a demonstrable risk that a person will flee the jurisdiction. Third, explicitly require that a person must not be remanded for an offence that is unlikely to result in a sentence that is imprisonment. And fourth, remove all bail offences. As previously mentioned with Aunty Tanya Day's story and the decriminalisation of public intoxication, experts had also been arguing in their field about bail reforms, and that also includes a 2007 Bail Act review by the VLRC, and they made similar recommendations to what Pockham's Law did, and it didn't really get them very far. However, it was the advocacy again of a First Nations family, and Veronica's family, and their bravery in telling her story and the horrific events of her final days and hours that finally made Victorians listen and Parliament pay attention. The coroner also really bolstered the advocacy of the family, and they found a few main things, but we don't have time to go into all of it. I would highly encourage you to read those findings. But some of the things they did say was that the bail laws were a complete and unmitigated disaster, discriminatory to Aboriginal and Torres Strait Islander peoples, and that nearly everyone involved in the decisions made from Veronica's arrest to her passing had breached her rights under the Charter of Human Rights and Responsibilities in Victoria. Many of those recommendations made by the coroner have been implemented in the bail reforms that came into effect earlier this year. So another prime example of a First Nations family acting with strength, resilience and determination for their loved one who is no longer here and that unfortunately passed away in custody from a preventable death. This strength again should never be undermined by organisations and again amplified by our assistance, and it should always be led by First Nations families. I'll now hand over to Ash, who's going to talk a little bit about the changes on the ground and what effects they've had. Thanks.
So the intentions of the bail changes and bail reform were to they were aimed at reducing the overrepresentation of vulnerable cohorts, which include Koori women, Koori kids, and the laws were intended to make it less onerous for people who are accused of minor offences, who pose very little risk to the community, to be released on bail. Those amendments were made in, what was it, April, was it? March, month ahead of myself. And those changes were to expand considerations under Section 3A of the Bail Act that relate to First Nations people, requiring a judicial officer to take into account the systemic issues faced by First Nations people and factors that make custody particularly harmful for First Nations. It was amended to child-specific considerations to 3B to account for special needs of the vulnerability of a child and the detrimental impact that remand has on children. And I'm sure, we're mostly full of law students and legal practitioners here. I'm sure you're aware of those bail amendments, but you can, Google them if you want. But the impact, what we see at Legal Aid, and I've got a horrific data slide for you to hopefully squint and read, but I'll just talk you through what we have seen through our practice at Legal Aid. So you can see here, it's data on post-bail reforms, and where the dip is, that's where March, April comes into play when the legislation was changed. But what you can see is the numbers start creeping back up. So yes, we did see in the first April of bail law changes an 86% decrease in the number of Koori women on remand, which was what the bail amendments were set out to achieve. And those people that are, we've just talked about, if these laws were there, it begs a pretty important question as to why those bails existed and why didn't the system as a whole listen to the voices. We've heard for decades through royal commissions into Aboriginal deaths in custody, and I can go on. But you can see all of the numbers there start to trend back up. So although we have seen a significant reduction in Koori women on bail, the numbers are charging back up. I can't actually see the screen that I was going to read off, so I'm going to swap over here so I can read them out to you, sorry. The blue line represents people who we've seen on the bail and remand court who are at risk of homelessness. That was another cohort the bail amendments were to address. So you can see a significant drop in the number of people we see before the bail and remand court at risk of homelessness. The orange line is women, and the grey line is First Nations women. You can see there in the March and April drop, we're back up in August to just about where we were at pre-bail amendments. So the intention of the bail amendments lasted for about a month, and we're back up to where we were. So Koori women are still significantly overrepresented on remand, despite these laws that were changed based off our mob's advocacy. The other orange, the darker orange line there, that's Koori children facing remand. You can see too in the March and April there was a drop, and then we went back up for May, down for June, and back up to where we were now in August again. So still a long way to go for bail reform and applying those changes to the way we do bail applications. Now for Koori kids, in the weekend online remand court, which is children's court out of hours, VLA, Victoria Legal Aid, largely cover that. I think there's 2 or 3 kids that we haven't represented since the inception of the weekend online remand court. We have seen a reduction in the number of Koori kids at weekend online remand court, which is fantastic, but unfortunately the reduction hasn't been the same as it has for non-Aboriginal children. So yes, the numbers have gone down, but not as a higher rate as it has for non-Aboriginal children. And this data goes up to September, but the only 11-year-old child we've had at the weekend online remand court for the last 12 months has been a Koori kid. And we know, the Yuruk heard promises about doing every best effort to raise the age of criminalisation to 14, and the walking back of that or the backtracking on that. It's pretty disappointing to see that it's our mob that continually are significantly impacted by bad bail laws. But that's the data. That's what we're seeing. It was all right for a little bit, but we're back up to where we were. So there's more work to be done, and it challenges the statutory authorities like VLA and other government organisations to sit down and think about what we can do better so that these numbers and these legislation changes meet their intended purposes.
Thanks, Ash. The data showing that despite overall numbers going down, the overrepresentation still remains the same. And I think that there's lots of questions, we've heard it all through the conference, around police and courts looking at the way in which they determine who they arrest, who they charge, and ultimately who they give bail to. We've got time for questions. I'm not sure if does anyone have questions around systemic advocacy reform? Hi. Sorry, do you just, yeah, thank you.
So obviously there was a significant reduction initially, and then the numbers have crept back up again. What do you attribute that to, and how can we address that, I suppose? Probably not an easy question to answer, but...
I can just give anecdotally from our team, and then I'll hand over to Ash, because he's the data man. I have seen definitely police are more trigger happy now to do remand applications from the police station. So initially when these changes came into effect, we saw them kind of hold off on the remand applications and possibly bail clients where they may not have beforehand, and more clients were getting bail. We are slowly starting to see an increase in the police decision to do the remand application and then direct the client to court. Look, there's no way to say specifically whether there are more serious crimes that are being committed which would be a reason for bail not being granted. I don't have that data, but certainly anecdotally our team is seeing police choosing to now do more remand applications than they were when the initial changes came into effect.
I think me being the data person on the third last session on a 3-day session's a bit of a worry for us all, so sorry about that one. But I think, just as a Gunditjmara person, you've heard from my mob yesterday through the Arnies, systemic racism's the reason why it's rising. We've got more than enough more years than I've been alive's worth of recommendations about transfer of decision-making and power to community to build the systems that have been forced upon us, and I'm looking really forward to the journey we're on here in Victoria with Treaty Truth and The Voice. So that's what I believe it is. It's racist systems doing racist things.
Hello, my name's Fabian. I went to the Supreme Court about 2 weeks ago. Legal aid is representing my son. The background of my son, he's got intellectual disability and he's got some brain impairment. And I was horrified that he's not on bail, he hasn't been sentenced, and he's not on remand. His legal aid lawyers didn't make a bail application. My son is pretty much harmless. He's like a big giant, but she didn't talk about the application, and the prosecutor didn't talk about the application either at all. So what I'm saying is, should the legal aid person should have made a bail application or something, because he's been there for 4 years at in Port Melbourne. So I'm just a bit confused about my son's situation at the moment.
It's probably not one I can answer here for you. There's a range of reasons why bail applications don't go ahead, but I reckon I'll catch you after this if that's all right, and we can get onto it for you.
Does anyone else have any questions for Ash or Emily?
One more, thank you.
Thanks for your talk. It was great. You talked a little bit about the sort of multidisciplinary approach you can take in law reform and advocacy movements, particularly combining lawyers, politicians and media alongside the people really fighting the fight, people with lived experience. I'm just wondering, that's something that really interests me, that concept. Obviously, it's done informally when certain law reform issues emerge. Do you see are there any sort of more formal frameworks or partnerships that are being built in that space to enable more effective law reform and advocacy work?
I might just jump in quickly because it kind of relates to Unk's question. In one of the inquests, there was a recommendation for cultural capability uplift in the legal profession, and that's a project that Victoria Legal Aid started and realised that we weren't equipped as a statutory authority to do it right, and transferred the leadership of that program to Victorian Aboriginal Legal Service. So that's a three-way partnership across, some, I suppose what do we call them, key agencies in the legal profession to look at how we uplift cultural capability in the legal profession. We do have some constraints. It doesn't touch prosecuting agencies or judiciary or the bar, but it's a good start, and that's a clear way we can work together in a multidisciplinary team to uplift cultural capability in the legal profession so that we don't have people getting a minute and a half's worth of instructions for a bail application for it to be refused and then our mob dying in custody because of that.
I'll also just touch on very, very quickly, Shelley's in the wings, just in relation to public intoxication reform, the Day family, as well as representatives from the Victorian Aboriginal Legal Service, Human Rights Law Centre, the state government, health wasn't actually. Health did their thing separately, but justice all formed working groups in order to really work towards a law reform solution that switched into that health-based response. So there are ways in which policy and advocacy and reform do, in this circumstance, really change and shift the way laws are run.